Honorable Deputy Speaker, the subject is such that even though it is short duration discussion, it cannot be short, because this does not concern with only the state of Arunachal Pradesh, but it is a pan-India situation in which we have brought. Of course, when we had brought the RTI Act in 2005, we had brought that there should be transparency and accountability, and also that it should give timely government information to the people who apply for the RTI. I stand in this August House not because that I would like to evolve some guidelines for punishing those frivolous applications or to amend the RTI, which is not within the purview of this August House. But still, it is my feeling that the RTI activists that are taking part in Arunachal Pradesh on those issues, also my request with due regard and due respects to the commissioners in how we are dealing with the government departments, and especially the constructing departments, where the main objections come from. Several pleas have been filed in the Supreme Court seeking to curb the Misuse of Right to Information Act. One of the main players in those pleas are the additional requirement of local standing in the RTI applications, and there should be strict scrutiny of the intention of applicants seeking information. Such pleas are basically to curb Article 19, Clause 1, Subclause A of the Constitution, which amounts to seeking an amendment of the Constitution. A powerful narrative is being built around the misuse of RTI. Those in position of power are indeed upset with the citizen empowerment that this act has enabled. The RTI Act has allowed citizens to question arbitrariness and corruption and demand accountability. And this is something the powerful do not enjoy. The desire to truncate people's right to information displays the antagonism between those in power and the right of citizens to be empowered. Many government officials are now saying that citizens only seek information about matters that are connected with them, and felt that the purpose of object of RTI Act is defeated due to frivolous applications. Generally, the PIO would refer to most applications whom regularly file RTI applications as blackmailers, harassers, and people who misuse the Act. However, in reality, there are many RTI applications can be broadly divided into four categories. The first category, those who file RTI applications with the hope of exposing corruption, arbitrariness, or poor governance. And the second part is those who file RTI applications repeatedly to correct a wrong which they perceive have been done today. And the third, those who use RTI to blackmail people. This category largely targets illegal buildings, mining activities, or some other activity that runs afoul in the law. And the fourth category is those who use this to harass a public official with the intent to get some undue favor. Now, the last two categories very clearly comprise much fewer than 5% of the total RTI application. But unfortunately, when it comes to Arunachal Pradesh, the percentage is very high. And this we will have to curb with the moral support of all the citizens, the government, and also us legislators, where we have to take a stand that development works should not be stopped. Now the question is how blackmailers operate. As per the government officers, RTI blackmail threatens an illegal action which exposure and thereby extorts money. Why society has such touching empathy for the victims of the third category of RTI applicants? After all, these people have committed illegal acts. And the fourth category of applicants who seek undue favor must certainly be discouraged, and information commissioners will have to take some action on that. The constant refrain of some people who highlight the misuse of RTI Act is nothing but an attempt to muzzle a citizen's fundamental rights to transparency and information. The freedom of speech expression which is covered under Article 19, Clause 1, Subclause A, has been expanding over time. The reasonable restrictions that can impose on the freedom of expression are found in Article 19, Clause 2. These restrictions also apply to the right to free speech and publicizing. The exceptions of the RTI Act cover these logically curbs on freedom of speech, publishing and information must be consistent with each other. One of the most problematic statements by the Supreme Court was in the Aditya Bandyopadhyay judgment. In it, the court ruled that RTI should not be allowed to be misused or abused or become a tool to obstruct the national development and integration or to destroy the peace and tranquility and harmony among. This may be appropriate for terrorists, but not for citizens who simply use information. It is unfortunate that the public authorities were not castigated for flouting the obligation to ensure that information available suo motu under Section 4 of the RTI Act to the public and citizens are upbraided for using this fundamental right. The powerful find that RTI Act upsetting for it gives citizens the right to question their arrogance. That is why they are trying to discredit this law by talking about misuse. Many eminent persons berate the RTI Act and say it should be limited. There is widespread acceptance that statements, books and works of literature and art are covered by Article 19, Section 1, Subclause A of the Constitution, and they may curb meets with self and stiff resistance. However, there is no murmur when users of RTI label deprecatingly, even though it is covered by the same article of the Constitution. Everyone with power appears to think, I would risk my life for your right to express your views. Do not agree with you if you use RTI in a manner I do not approve. An information seeker can only ask for what is on the record if the records expose wrongdoing. It is silly to blame the RTI Act or citizens who use this law. This would be like blaming media for some scams unearthed by it. India is rated among the top 5 countries in terms of legal provisions, but ranks poorly in terms of implementation of these laws. The only systematic large-scale survey of RTI applications was undertaken by the Research Assessment and Analysis Group, which found that less than 1% of the RTI applications could be termed frivolous. Now, there is a need to evolve guidelines to stop misuse of RTI law. There are people who put on their letterheads RTI consultant or they call themselves RTI activist. Now, this is a question, a big question to ponder upon. Is that an occupation? Is RTI activist an occupation? There may be an axe to grind beyond RTI request. Therefore, it is important to find a way to stop the abuse of RTI Act. The Apex Court, while hearing a plea seeking to curb the abuse of RTI by frivolous applications, said that the huge flow of applications RTI is a serious problem. The Supreme Court further stated that the right to information cannot be unrivaled right and said there is a need to stop misuse and criminal intimidation by those people who are not connected with the issues raised. People who are no way connected to an issue file RTI is sometimes amount to criminal intimidation, which is a nice word for blackmail. We are not against the right to information, but there is a need for guidelines. It cannot be unrivaled again, said by a bench comprising of Chief Justice S.A. Bobde and Justice B.R. Gawal and Suryakant. The Apex Court made the remarks while hearing a plea of filing of vacancies in information commissioners in the Central Information Commission and the State Information Commissions. Calling the huge flow of RTI applications a serious problem, the bench said, though it is not opposed to the transparency law, there was a need to evolve a mechanism to ensure that only affected or concerned person take recourse to the legislation. The Chief Justice of India, while sharing his personal experience as a judge of the Bombay High Court, said that an official once told him that functioning in the Maharashtra Mantralaya, in the ministry in Maharashtra, was paralyzed because of queries under RTI. Lawyer Prashant Bhuchan appearing for activist Andali Bhajwaj, while referring to various apex court judgments, stated that the public had a fundamental right to know, and information seeker does not need to have a locus or personal interest in seeking information under RTI. Citing the examples of electoral bond schemes and award of a government contract, Pusat said, unconnected persons can take recourse of the RTI in seeking information. In such cases, no political party would like the scrutiny, and in latter, a loser in the bidding process will have the fear of getting blacklisted. The fear of action from the people in power prevents many connected persons from filing plea under RTI. However, the bench made a remark that let somebody in the business do this. One can understand if a connected person files an application under RTI, it cannot be the case anybody seeking anything. It added that there is some kind of filter and some guidelines, the bench further said. Now, Honorable Deputy Speaker, sir, the reason why I have brought this for discussion, and I hope that most of my friends will participate, it will be kind of a knowledge to all of us that what actually is happening in our state of Arunachal Pradesh. Sir, today is the Ides of March. It's 15th of March. It is the Ides of March. Most of us must be knowing that a soothsayer had gone to Caesar and said, beware the Ides of March. And in the Senate, when Caius Cassius and Brutus stabbed Julius Caesar, he had said, et tu Brutu, means you to Brutus. So the story goes that when the body of Julius Caesar was laid to rest in front of the public, and the public said, and Mark Antony came forward and said, friends, Romans and countrymen, lend me your ears. I come to bury Caesar, not to praise him. Brutus says that Caesar is ambitious and Brutus is an honorable man. But how he converted the public in saying that Caesar wanted to be an emperor, but by his elocution, how Mark Antony made the people realize and shout for the will. So that is the locus standi now. Who is Caesar? Caesar is the RTI Act. Who is Brutus and Caius Cassius? They are the fraudulent RTI activists. Who are then the Mark Antony? Mark Antony is the people who are really determined that yes, we want to bring transparency, we want to know the knowledge from the government, and the commissioners are the soothsayers who guide, who give decisions, who lead us. So, Honorable Deputy Speaker, sir, whatever good we had intended, it is our government, the Congress government which had brought this act, so that there would be transparency, there would be coordination, there would be less corruption, and that was the intention of the government. But gradually, we have to make this act more strong, but it does not mean that the RTI, the right to information, is turned into a right of income. So it is very unfortunate, because the government has to go on. Works cannot be stopped. Now, what is the way forward? How do we check it? Of course, we cannot bring some provisions, nor we can amend the constitution. If at all it has to be amended, it has to be amended in Parliament. But we can have a say that where we are wrong and what have we done wrong. Because nowadays you will see that so many RTI applications are there. And investigations are there, so much stuff, waste of time and money. And after that, at the end of the day, you hear that they have withdrawn the case. Why have they withdrawn the case? So that comes under the third and fourth category of which I had mentioned. They are the Caius Cassius and they are the Brutus. With an intention that Caesar was a good man, but they had to stab him because through these means, ways and means. So at least there has to be a provision that if these are frivolous cases, if these applications are frivolous, the RTI activists, then they should be also punished. There has to be a law, because the law does not depict anything about punishment, about the frivolous applications, or there are no certain guidelines on that. So, in this August House, I know there has to be some rectification, some training, and awareness of the provisions of the Act. I would, through your kind self, appeal to the Law Minister and also to Honorable Chief Minister that the officers of Arunachal Pradesh have to be at least trained what the RTI Act is. Either we are wrong, either our government officers are wrong, and they fear these activists and just pay off the funds and pay off the money, which leads to more wrong. When you do a wrong, you cannot do a second wrong and try to save yourself. So, Honorable Deputy Speaker, I would request that through you, the government takes steps to give training to our officers and awareness about the RTI Act. RTI Act, when somebody applies for an RTI, suddenly the officer is he becomes fearsome, or he is very much afraid. So we have to clear this doubt. We have to make them clear that we are a government, we are working for the people, and just an RTI Act cannot show the faults in you. If you have done the work properly, why should there be, that fear psychosis in you? So as, frankly speaking, sir, at the end I would just like to quote. Again, that is from the Merchant of Venice. I hold the world as the world, Rachinio, a stage where every man must play a part, and mine a sad one. I know I'll get a lot of criticism. I know I will get a lot of complaints from the RTI activists, or even from the commissioners. But somebody have to say a spade is a spade. I'll have to tell them that what is wrong is wrong. Now, through you, I would like to appeal to the House, the August House, that if there are feelings that yes, the RTI activists in one way or other are wrong, should also respond, so that I may also be protected from these kind of third or fourth category RTI activists. With these few words, sir, I thank you very much for allowing me to place this in the floor of the House.